DeWaal here, and this is Bridging the Week for September 28th to October 2nd, and today is October 5th, 2015. Good morning. Last week, the European Securities and Markets Authority issued the equivalent of its final rules on a host of regulatory initiatives adopted since the 2007-2008 financial crisis, including the Markets and Financial Instruments Directive 2. Once effective in January 2017, these rules will substantially change the way securities and derivatives transactions are effectuated in the European Union, with spillover effects worldwide. In addition, software glitches resulted in two firms paying large sanctions to security regulators in the US. We have a lot to cover this week, so let's get started. The European Securities and Markets Authority issued the equivalent of final rules, known as technical standards, to implement three cornerstones of the European response to the 2007-2008 financial crisis: the Markets and Financial Instruments Directive 2, the Market Abuse Regulation, and the Central Securities Depositories Regulation. The final technical standards implementing MiFID II are intended to subject to regulatory oversight the majority of non-equity products traded in Europe, and move a significant portion of over-the-counter trading in Europe onto regulated trading venues. The final technical standards will, among other things, establish a methodology for calculating and applying position limits for commodity derivatives, as well as determine when a non-financial firm might be subject to capital requirements, impose organizational requirements on investment firms, regulate high-frequency trading, and require non-discriminatory access to clearinghouses, trading venues, and benchmarks. The Market Abuse Regulation is aimed to increase market integrity and investor protection, while the Central Securities Depositories Regulation purpose is to harmonize the functioning of central securities depositories in Europe. MiFID's final technical standards are now being considered for approval by the European Commission for up to 3 months. Countries of the EU must adopt relevant provisions into national law by July 3, 2016. MiFID II is scheduled to be fully effective on January 3, 2017. I discuss in a bit more detail some of the proposed requirements regarding trading commodity derivatives, including position limits, and some requirements on investment firms in the article version of Bridging the Week on the website. Check it out. Latour Trading LLC, a Securities and Exchange Commission registered broker-dealer and proprietary trading firm, agreed to pay more than $8 million to the Securities and Exchange Commission to resolve charges related to alleged breakdown in controls in its electronic trading infrastructure. According to the SEC, from October 2010 through August 2014, Latour sent approximately 12.6 million orders for over 4.6 billion shares to stock exchanges that did not comply with the requirements of the SEC aimed to help ensure competition among U.S. security markets and fair prices, so-called Regulation NMS. The SEC charged that, because of a programming change made to software used both by Latour and its ultimate parent company, Tower Research Capital LLC, orders sent by Latour did not comply with requirements under Regulation NMS. The SEC also charged Latour with violating an SEC rule that requires broker-dealers to, quote-unquote, appropriately control market access so as not to jeopardize, quote, their own financial condition, that of other market participants, the integrity of trading on securities markets, and the stability of the financial system, end of quote. The SEC said that Latour violated this rule because the developer who changed software for both its parent company and itself was not under Latour's exclusive control. A federal judge in New York mostly granted J.P. Morgan Chase Bank's motion to dismiss claims brought on behalf of unsecured creditors of Lehman Brothers Holdings, Inc., related to J.P. Morgan's requirement that Lehman Brothers, Inc., LBH's broker-dealer subsidiary, post extra collateral with it in September 2008, shortly before LBI filed for bankruptcy protection on September 15th. At the time, J.P. Morgan required that Lehman Brothers pledge or post $8.6 billion of extra collateral with it in order for J.P. Morgan to continue to maintain a credit and liquidity facility for Lehman to process tri-party repurchase agreements where J.P. Morgan served as agent. Following Lehman Brothers' bankruptcy, J.P. Morgan used this collateral to offset Lehman Brothers' obligations to it. Lehman Brothers' unsecured creditors claimed that J.P. Morgan used its quote-unquote life or death leverage to extract virtually all of Lehman's remaining liquidity prior to its bankruptcy filing and establish an $8.6 billion quote-unquote slush fund for its own use. The judge rejected this argument. He claimed such a position rested on the quote-unquote fundamental premise that JP Morgan was obligated to extend credit to Lehman Brothers, and thus its demands for additional collateral were wrongful. Reviewing the relevant customer agreement, the judge said, this premise was not correct. Credit Suisse Securities agreed to pay the Securities and Exchange Commission $4.25 million for its alleged failure from January 2012 to 2014 to electronically report accurate and complete securities transaction information to the SEC upon its request. This failure is related to connection with 593 submissions of so-called blue sheet data. According to the SEC, the errors were caused by a number of different situations, including migration to a new blue sheet reporting system that contained a coding error and the inadvertent failure to remove a dry run flag, breakdown in the interface between the firm's blue sheet reporting system and its order management system, and breakdowns in the process to validate the accuracy and completeness of blue sheet submissions. And finally, Daniel Baumann, a floor broker registered with the Commodity Futures Trading Commission from 1982 through 2014, agreed to pay a fine of $34,940 and a permanent trading ban on products regulated by the CFTC for violating speculative position limits on 6 days in 2010 and 2013. According to the CFTC, Mr. Baumann violated speculative position limits in 2 accounts, one in his own name and a company he controlled, in Chicago Mercantile Exchange live cattle futures contracts from 12 to 96 lots on the 6 days. The CFTC said Mr. Baumann realized $34,940 of ill-gotten gross profits as a result of his trading in excess of prescribed limits. 6 days and less than $35,000 profits equals a lifetime trading ban? What am I missing? Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week and ciao.